Okay, so first let's talk about who is a veteran. And one of the things that you'll notice is the definitions are different. So if you're working with the VA court, if you're working with another organization, they might have a different definition of who is a veteran. The importance of this definition is this is who is a veteran for VA disability purposes. So it's someone who served in active military, naval, or air services and who was discharged or released under conditions other than dishonorable. So we're going to unpack that. So a person who served, this is regular active duty, all 5 branches, Army, Navy, Air Force, Marines, or Coast Guard. We also have the reserves and the National Guard. These are folks, they must have been activated to federal service. This is especially with the National Guard. They must have been activated to federal service. And they must have become injured under federal service. We'll talk a little bit about LOD determinations. This is determining someone became disabled while they were activated to federal service. This is crucial for a National Guard case. In addition, we also have, these folks are considered as veterans, full-time commissioned officers in the Public Health Services, the Environmental Science Service Administration, and NOAA. We also have cadets at the academies and students at the preparatory schools with active duty commitments. Okay, so this actually comes into play quite a bit. Eligible discharges. So we need someone who served appropriately under federal service or had the appropriate commitment. We also need someone with an eligible discharge. So the eligible discharges are honorable, general under honorable, and general discharges. Ineligible are dismissals, other than honorable, bad conduct, dishonorable. There are a couple things that folks can do if they walk in with these discharges. For one, you may have someone with multiple discharges, only one of which is bad. If they became injured, if their injury that can be service connected was they were discharged under honorable conditions or under an eligible discharge, that will work. They can also go back, they can ask to have their discharge upgraded. I will tell you, with some of these, we don't do discharge upgrades, but with some of these, it's going to be a real long shot if they've been court-martialed, if they've gone through all of that. So, but they can actually go back and ask to correct their discharges if they feel like the discharge is wrong. It's also possible to take someone with a bad discharge, and John can talk more about this, but to adjudicate a period that was honorable. And this is the PTSD, guys. So some folks ended up with a bad discharge. Some of the folks that were deployed multiple times, back to back to back, there's a few that ended up with bad discharges. They can be adjudicated for a period that was honorable. So even though it's a bad discharge, it is possible to get them VA disability benefits. But for starters, when the person walks in your office with a dismissal and other than honorable, any of the ineligible discharges, just let it go off in your head that this is not going to be automatically eligible. You're going to have to dig a little further, or you might not be able to help the person at all. Okay, so these are some of the types of VA disability claims. The reason I'm highlighting these 3 types are these are the types in the CFR that we are required to talk about to get you accredited. It's not that we don't want to talk about the other types, but you don't want to be here for that many days. So the types we're talking about are Veterans Service-Connected Disability Compensation, Veterans Non-Service-Connected Disability Pension, and Dependency and Indemnity Compensation. The last one is for dependents, the first 2 are for the veteran. And we're going to start with Veterans Service-Connected Disability Compensation. Okay, so Veterans Service-Connected Disability Compensation, the easiest way to think of this is where somebody has an injury that occurs first or is aggravated when they're on active duty. The first thing we want to look at is make sure they're a veteran. So you're going to look and make sure they served appropriately, they have the eligible discharge. Then you're going to make sure they have the minimum duty requirements for Veterans Service-Connected Disability Compensation. So at a minimum, regular active duty, as long as they had at least one day, they could have gotten injured the first day of basic training, and that could be enough. With National Guard and reserves, it's a little trickier. Of course, like I said, they have to be activated to federal service. It can occur when they're activated on active duty for training. There's a couple different ways it can occur here. I'm not going to go over them all, but you have a copy of the slides. Especially with Guard, you have to dig. You have to make sure that it happened while they were doing federal service. Anyway, I'll let you go through the slide to see what the minimum duty requirements are. And actually, let me go back real quick. So when I was talking about the LOD determination, for reserves and for Guard, especially for Guard, this is the line of duty determination. This is something, those of you in the Guard will know this. This is something when an injury occurs, there's a line of duty determination that's supposed to be made. It's not always made. So this can be a problem. But if this is made, if the veteran comes into you and has an LOD determination, you're so far ahead of the game. This basically is signed off saying, this guy was injured on active duty, here's what happened. This you almost always need for the Guard to be able to get them service-connected disability compensation. If they come in without it, because it does happen where they're injured and they don't get this, they can go back and try to get it. I will tell you it's an uphill battle, but if they were injured while they were activated to federal duty, it's worth it to help them through the uphill battle, but you're almost always going to need this.
May I add just one thing?
Sure.
One way that you can deal with this if the veteran does not have a line of duty determination is to produce a contemporaneous medical report or a police report. I've won an appeal based upon a police report from numerous years ago. VA continually denied, saying, no LOD guardswoman. Well, we also had a police report, and ultimately the Board of Veterans' Appeals agreed police report was sufficient. But it's very much an uphill battle. So as she says, the LOD is the key.
I'm glad you said that. Anything unusual, expect to appeal it.
Absolutely, absolutely.
So veteran service-connected disability compensation, these are the type of claims you can file under this. So these are the folks, there's direct service connection. This is the guy who goes to Iraq and gets injured. Direct service connection. You know, he's on active duty, he's performing active duty, he gets injured. Secondary service connection. This is the guy, so a common one I've got as an example, this is the guy, say he's got a traumatic brain injury from being in Iraq. He was hit by an IED, he's got a traumatic brain injury. Later on, he develops depression from his traumatic brain injury. That can be secondarily service-connected. That's still service-connected disability compensation. It's a disability that's caused by or aggravated by this disability that happened while they were on active duty service. Then you've got straight up aggravation. So this is the guy that played football in high school, injured his knee, goes into the service, and serving whatever he did, it takes his knee beyond what the actual progression would have been. So this is aggravation. This is also direct service connection. Then we've got presumptives, and I'll go over presumptives a little bit more. These are things that are presumed to have happened because he served. And they're just things that Congress decided, because this vet was exposed to this or served in this arena, if he comes down with this disease, we're going to presume that it happened while he was serving. And I'll go over that in more detail, because I realize right now that probably doesn't make a whole lot of sense. First, we're going to go over the 3 elements that you must meet to prove service-connected disability compensation. So there's 3 elements that you have to meet. The first element is there has to be a current disability. So you might have a guy who is blown up with an IED in Iraq, and by a miracle, he is perfectly fine now. If he's perfectly fine now, he doesn't have a VA disability claim. Perfectly fine, they can't compensate you for anything. You have to have something going on now. So this requires a medical diagnosis. If there is no diagnosis, theoretically, if there is no diagnosis, you can make the claim and VA is supposed to give him a medical examination to make the diagnosis. It's actually better practice for him to have the diagnosis in the first place. Hawaii is actually probably one of the, well, so all vets can go to VA, but Hawaii is also one of the best places to be able to go see a doctor. It's a good idea not just to file a claim without a diagnosis. It's a good idea to have him go to the doctor first and to see if he actually does have something going on. But if it's impossible, you can actually make the claim and VA is supposed to give him a medical examination. Okay, so we talked about the current diagnosis. Element 2, there has to be an event in service. So you have a current diagnosis related to this event in service. So this means something happened. He got blown up by the IED, whatever it is that happened. He was in the area of exposure for presumptive claims. It was aggravated while he was on active duty. Something happened in service. So element 1, current diagnosis now. Element 2, something happened in service. Element 3 is what almost every veteran will lose on, and it's the hardest thing for veterans to understand. So you'll find yourself trying to explain this to the veteran, because theoretically it kind of seems like there should just be element 1 and 2, right? You got blown up in service, and 3 years later you're still dealing with the effects of being blown up in service. It kind of seems like that's it, but there isn't. That isn't. Element 3, there must be a medical nexus between the event in service and the current disability. So this is the legalese. So let's say you're exposed to something, you were diagnosed with post-traumatic stress disorder in service, and you've got post-traumatic stress disorder now. There has to be a medical nexus, and the medical nexus would be the psychologist saying, it's as likely as not this is related to the event in service. That's the medical nexus. That's the legalese. What the doctor is actually saying is it's a 50-50 chance. Could have been, might not have been. It's as likely as not. Just rolling the dice. It's 50-50. So that's the minimum standard. I mean, with the one I just described, the doctor's probably going to be a little over 50-50. But that has to exist. There has to be a medical opinion that says it's as likely as not this started in service or was aggravated by service. And this is what most veterans will lose on. Another thing to know is, John can second this. A lot of claims get turned down, so a doctor says it's as likely as not, and VA comes back and said, yeah, he didn't review the VA disability claims file. He didn't review the medical records. What I do when I have an interested doctor that wants to help out is I'll just give them a CD with all those records. It's a huge pain for them. I'll usually highlight any of the important parts, but let them look at the whole thing. But you want to give the doctor access to all the records.
Can I throw in just one point?
Sure.
The thing that you want to do with your clients is never advise a client to go to a physician for an opinion. Always advise a client to go to a physician for consultation and treatment, to actually engage with that physician and have that person as their practitioner. At that point, the doctor may well be willing to help their patient. But if you send a client into a doctor's office and they bring a VA rating and say, you know, doc, I need an opinion, the doctor will say, I don't do those kind of things. So just remember that. Go to a physician for legitimate treatment, engage with that physician, And then the physician may well be inclined to analyze your records because you're now his patient or her patient. That's just a real key practice tip because it will not happen otherwise. And Diane and I have been in this business, I don't know how many years. We send people to physicians throughout this community. It's the only way it'll work is actually engage with the physician.
John's absolutely right, and it makes sense. I mean, this person is going to form an opinion on what they believe. This needs to be their patient. It
Right.
needs to be someone that they're familiar with. I mean, there are places that you can pay. You can send them all the medical records. We're in Hawaii, so there's no one here, but you can send them all the medical records, and I think it's like $700 to over $1,000. I've never used them, but I know a lot of attorneys do. They'll analyze it and form an opinion. Yeah.
It's a waste of time if you've got
The
a
VA
practitioner.
knows who these folks are.
Yeah, and you know, VA doctors can also take care of your clients. However, VA doctors are prevented by policy from actually writing out opinion letters. They used to do it. For whatever the reason, VA's taken the policy, they won't do it. So again, the key is to be engaged with your VA physician if that's who you're going to, so that the doctor can actually put that in her medical records. So she can, you know, as she's going to have the old SOAP notes, which I use as well. You know, and there's an observation or objective and assessment section where you really take a look at what the problem is. And that's where the doc's probably going to do what she needs to do. So that's how you work with a VA doc. But if you call up VA and say, hey, I need an opinion, they'll just shut you down immediately. So that's another thing to keep in mind. And there's some other distinctions we can talk about, but I think that's the real essence, is engage with a decent practitioner in a legitimate way.
And VA also has its own doctors to form these opinions.
Yeah.
These aren't the veteran's doctor, so sometimes you get things that are kind of crazy.
Right, and here's how you deal with that, is you're going to have, your client is going to go in front of a C&P examiner, basically compensation and pension examiner. It might be a private doctor with various agencies, QTC is one of them, or it might be actually be a VA compensation and pension doctor. Well, they'll review the C-file, at least evidently they will, and with some of the other practitioners, you know, they will say they reviewed it, but then perhaps they didn't. You can always question the C&P. For example, if the doctor never examines the patient, talks to you for about 5 minutes, makes some jokes and leaves, I will contest that immediately. But if you have a C&P exam and you really disagree with it, the way that you deal with it is with your own medical evidence, with your own practitioner. And that's why I tell my clients, have a physician, be engaged with them, have a psychologist. And by the way, never have your client, if it's a psychiatric case, just go to a social worker. I don't want to denigrate social work, they're great therapists, but you need a PhD level therapist or an MD psychiatrist.
Yes.
That's the key. Otherwise, you have no way to cross swords with the VA because they have, at a minimum, a PhD psych examiner. So remember that. But you can really show, for example, in psychiatric cases, the way in which your client will prevail almost every time. If you've got a legitimate psychiatric condition and you meet the 3 legs of the claim, happen in service, still have a condition, and there's a medical nexus. So you've got those 3 elements. And your client engages with a psychotherapist of PhD level or above, you'll have a good history of psychotherapy notes. And never go to psychologists who will not do that. Never recommend to someone, if you learn in the course of business, they don't take good notes, don't use that person. Always go to somebody who actually documents her cases. So a year, 2 years down the road, I go into an appeals court and C&P exam says, well, no, there's no PTSD here, and they saw my client for about an hour and they skimmed the record. That's fine, and I'm not going to denigrate them. I'm going to give them all the weight that is due, and they are experts. I'll never put them down. But what I'll say is, Your Honor, we have to balance. And when we balance, we look at 2 years of psychotherapy notes with a clear diagnosis of post-traumatic stress disorder. When the judge makes her ruling, it's going to be all things being equipoise, the benefit of the doubt goes to the veteran. And we'll talk more about that later on in the seminar.
Can you tell this is the element that we mostly lose on? What were you going to ask?
Can I ask a question related to the provider-patient connection?
Sure.
So in Hawaii, every veteran's eligible. I'm Hawaii veteran, right? So we work and stuff. every veteran's eligible for a community provider, you can get your service, so I got community providers. Would it be reasonable to suggest to a veteran to have, if they're enrolled in the VA system, we'll use that assumption in this, to have them say to their primary care physician, can I get a community provider?
Yes.
Yeah.
Yes.
Would that be
It's the way to do it.
Absolutely.
Yeah, yeah. And their physician has to be the one now that refers them. But yeah, it's totally legitimate.
So that would keep it connected. at
Yeah.
that
Yes.
point.
Yeah,
But
that's the way to go.
I'll give you a CNP story too. I just looked up one yesterday. I've got a vet, can't use either hand. Both of his wrists are messed up and his hands are messed up. And this CNP examiner just reviewed the records. He missed that it's both hands. He only got that it's one. So it was an assessment on whether or not this veteran could still perform work. And since he missed the other hand, I mean, there's a lot of records on it, but somehow he missed the other hand, he decided the veteran can still perform work. So this is one of the reasons why you want to have support if you can get it. I mean, I can win that without another doctor saying anything. It'll just take longer because I actually have to stand up and get their attention and say, hey, 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 he's got this other hand and all these medical records, and look, he can't use that one either. But yeah, that's where the fight usually comes in, is this nexus and all this stuff that goes on here.
So would it be advisable to say to the veteran, when you go see your physician, take somebody in with you, a significant other, or somebody like that, to sit with you?
Oh, the CNP examiner?
Yeah. Because I know if I go to the doctor, I can bring somebody in the room with me.
Yeah.
So that's my witness, my advocate now.
Yeah, and
Would that
actually,
help in this particular situation?
this one wouldn't because he only reviewed the records, but yes. I'll admit, I sat in on my husband's CNP exam, identifying myself only as his wife, of course. But I have folks do statements. If it's funny after, so these aren't the VA docs, but sometimes they schedule out with contractors. And I know there's one agency, gosh, there's one doctor in particular, she's never examined anyone, she only talks. So I'll have them give me statements like about what happened so that we can use those statements to say, hey, we need an actual examination, because they won't not do it. But we can at least get the statements to say we need at least a fair one. We need someone to examine the vet. So anyway, that's element 3. So you've got your 3 elements. Something happened in service, something's affecting you now, and there's a nexus, a medical opinion saying the thing that's affecting you now started with the thing that happened in service, whether it's aggravation, whether it was an event, whatever. But those are your three legs of the triangle. Okay, so let's talk about presumptive service connection. You will learn to love presumptive service connection, because with this, after pounding away at those 3 legs, presumptive service connection means we're going to presume there's a nexus. We don't have to get a medical opinion. Nobody's going to miss half the records and miss a hand, none of that. With presumptive service connection, you only need something happened in service and something's affecting the vet now. He's diagnosed with something now. So the presumptive service connections are written out in the regulations, and there's different kinds. Probably the most known is post-traumatic stress disorder, and we'll go over that in more detail. Chronic diseases, so you get diagnosed with diabetes mellitus in service, they'll assume, or 1 year following service, they'll assume that that's related to your service. If you're diagnosed in service and you still have it now, they'll assume that that goes back to your service. Same with tuberculosis. Continuity of symptomology is treated the same as chronic diseases. It's a separate part of the CFR. But if you see continuity, just treat it as chronic diseases. Look up at 38 CFR 3.309A, which diseases are compensable. Those are going to be your chronic diseases. Same with continuity of symptomology. So I'm using all these big words. Basically, anything written out at 38 CFR 3.309A if the veteran was diagnosed with it in service and still has the diagnosis now, he can get compensated for it. That's the short of it. So I think, yes, I want to talk a little bit more about post-traumatic stress disorder. It's presumptive. There needs to be no medical nexus if it's related to events in combat. And that's anything that's related to events in combat. We don't have to have a medical opinion. There has to be some sort of evidence, but there doesn't have to be that medical opinion. And we need a diagnosis now that something happened or that something's affecting the veteran now. But what I mean by that is, let's say we have a soldier, he goes into combat, diagnosed with PTSD in service, still has the diagnosis now. All he has to do is write out a statement saying that it's related to combat. That's enough. For things that happen in combat, we can presume that there's a service connection. We can presume there's a medical nexus.
And there's a beautiful way to look at the combat presumption. If you were in war and you're carrying heavy rucksacks and heavy armor, and you've got maybe about 110 pounds of kit and maybe you're a 140-pound soldier, and you've got shoulder problems later, you've got back problems, knee problems, if it's consistent with the conditions of combat, and it is, carrying heavy loads in the field, I can get that first leg of the claim presumed right there, if it's consistent with being in infantry. So that's kind of the way to visualize this. Is it something consistent with warfare? If it is, you're going to have that first leg of the claim for sure.
So here are some other presumptives. Gulf War syndrome is a big one. It's hitting right in the middle, but diagnoses, so you've got a vet now. He's diagnosed with fibromyalgia. That'll be presumed. Chronic fatigue syndrome and IBS. Those are the three biggest ones that we see. If they have the diagnosis now, it'll be presumed that it's part of Gulf War syndrome. This was Congress taking all of its medical knowledge, considering they're all lawyers, and figuring out exactly what we were going to assume happened. So yeah, those three, if they have them now and they served in the theater, they can get service connection with that without a medical nexus. Infectious diseases manifest to 10% within 1 year of separation from service. The exceptions are malaria, which can be connected at any time. So if you have malaria, they'll assume that it started in service. There's also no time limit for TB, and I'm not even going to try to say it. I've never had anyone with that. Actually, I'll try to say it. Visceral leishmaniasis, but I've never seen anyone pop up with that one. Here are some more, and my big recommendation with the presumptives, you're rarely going to run into presumptives. If they show up at VA, VA can help them file the claim. Presumptives, probably the ones that I run into, I guess that's not true. You're never going to run into presumptives. I run into Agent Orange presumptives and, yeah, military sexual trauma. But like the tropical diseases and disorders, I've never run into that. POWs tend to be really well taken care of. But what I'd recommend with these is I've listed all the CFRs. Take the slides and look up the CFRs, and it will tell you which diseases are presumptive for which veteran. So you're not likely to see a Korean War vet, but if you have a Korean War vet walk in, just look up the CFR and see what the presumptives are and see if he has any of those conditions, because that's what you can get him service connected for. And I will say you're not likely. When I first started in Hawaii about a decade ago, this little old man walked up the stairs, came to see me, sat down in the chair, and I take his VA rating to take a look at it. And I swear, it was early in the morning. I almost spit out my coffee on it. He was a World War II vet. So you're not likely. but it happens.
I mean, I'll be frank, I've been in this business longer than Diane. I've served hundreds of World War II vets. So, I mean, a lot of those folks are dying now. Although I'll say this, our Vietnam vet population is dying at a faster rate than the World War II people. So, yeah, there are, I mean, I've represented almost every guerrilla in town, Philippine guerrillas.
Oh, yeah.
I've got numerous World War II vets, and they're slowly going back home, if you will. But definitely, you will see somebody down the road. Radiation exposed vets, sounds like an anomaly, you'll see them. And they're out at Johnson Atoll during various nuclear tests, or they're out in Alamogordo or other places. So yeah, you'll see them, they'll be rare, but they're very compelling cases. Very, very compelling cases.
Yeah, mine that day was 93 years old.
Yeah, right. I had a 90 plus veteran come to see me once a week for years and years, and I fought a couple appeals, won them for him. He'd take the bus in to see me, and you know, they're just a beautiful group of people, just a wonderful group of veterans.
Okay, so there are things that will not be compensated. Just like if you walk in with a bad discharge, there are certain things that they presume are the result of willful misconduct. Venereal disease, drug addiction and alcoholism, that's probably the biggest one. You can actually get it service connected, which we've both done, but it has to be secondary to something else. His PTSD is really bad and he's drinking a lot because of it. Injuries or illnesses sustained due to the use of drug or alcohol. I had to explain to a vet recently that if you're drunken off duty and you shot someone and they shot back, that one's not going to work. And especially with the court-martial that followed. Things that happen while you're AWOL, you can't get compensated for that either. Although I will say that's another one that walked in. I had a guy walk in. He served in Vietnam, and he'd never been discharged. He'd gone AWOL and managed to get himself arrested, and they never looked for him, and he never went back, and he was still on active duty. I think I sent him up to you, and you actually got him service connected.
It may be, Diane. There's so many people, it's hard to
Yeah, I
remember
know.
them all.
I'm thinking that's what happened.
We do the best we can for everybody that walks in the door.
Anyway, birth defects also will not be compensated. Developmental disabilities, glasses. Personality disorders, that's probably the worst of them. So it's sort of amazing how many people get diagnosed with personality disorders on active duty in VA. So they say about, well, I don't know, but this is kind of a constant fight. So they don't compensate for personality disorders, and you send a vet, and it's like they come back and their diagnosis is like 5 different personality disorders, and meanwhile, they're talking to you about things that sound like depression or PTSD.
And the strange thing about personality disorder is the VA are going to tell you, or perhaps the military on exit, it's a great way for the Navy to throw people out, personality disorder. The problem is, if you look at their MEPS, their entrance physical, they didn't have any psychiatric history. Now, if you study the DSM-5, you'll learn that a personality disorder probably manifests in late adolescence, early adulthood. But if it's not been manifest at the beginning of your service, how is it later that you're processed out with a personality disorder? Well, there's a good reason. It's very easy to do. It's easy to throw people out. So that's an uphill battle, but we can fight that with an expert opinion, and we've done it many times. Right, Diane?
You sent me one of those, actually. So this woman, no history, she attempted suicide while she was in service, and they put her in a psych hospital and let her back out, and she did fine for a while, and then she attempted suicide again. They actually changed her diagnosis while she was inpatient at the psychiatric facility to personality disorder. She was out within 30 days. Personality disorder, first, this is one of the things, they actually put this on your discharge paper, so it goes on your DD-214. Reason for separation from service, it says personality disorder. So anytime you show this paper, anytime you have to show this paper for jobs, it's got this diagnosis on it. This is the only one they do this with. But it also meant she was not eligible for a medical discharge. She wasn't eligible for VA benefits, we had to go back and prove it was depression.
You won that at CAVC, didn't you?
I did.
Yeah, yeah. It was an excellent case.
Yeah, but it was pretty awful by the time she got to me. By the time she got to you,
Right.
it had been 10 yeyears.
Right.
She'd been fighting this for 10 years. She'd been homeless. She'd been in and out of the psych ward. She'd had more suicide attempts. It was bad.
So that personality disorder is really a mischaracterization, and you can rebut it, but you need decent psychotherapy for your client in order to do that. But again, that's the foundation. The only thing I can do is utilize sound medical evidence.
Exactly. Okay, so we keep talking about getting people rated. So I wanted to show you the schedule of ratings. This is just one rating. I suspect these are written by lawyers, so I don't know if they make any sense to doctors. But this is the spine, and one of the reasons I'm using the spine as an example is, for those of you who served, back problems are a big one, and especially for all the stuff you had to carry around. And this shows you how hard it is to get a high rating for back problems. It's kind of stunning because I see people completely incapacitated by back problems, probably more than anything. Probably more than anything, I'm sitting at my desk, looking across my desk at this person, sitting there, squirming in the chair, asking to stand up, maybe pacing a little. Maybe they'll start to sweat if they're in there long enough. This is just a typical back problem. This is the rating for a back problem. All the ratings are written in a similar fashion. It tells you what you're looking for in the records and what the percentage rating will be. You don't necessarily have to meet every criteria in the rating, but you have to be close. We'll also talk about analogous ratings, analogous ratings. What that means is so the ratings themselves, what the 20% means is 20% decreased work efficiency. So let's say you have someone with a back problem and their medical records don't look like this, but they're decreased in their work efficiency by 20%. This is a harder fight. I will warn you at the outset, this is a harder fight. But you can fight VA for a 20% rating on the fact that it's analogous to 20%. It's a 20% decrease in their financial ability. So it's analogous to a 20% rating. So you can argue for that.
Sorry, it's not specifically on the schedule of ratings, but just going back to kind of the willful presumption for drug and alcohol. Like for insurance cases, there's been like federal cases where people go and try to contest. I know everything's bifurcated into, this is mental health, this is personality disorder, but a lot of the research is showing that there is a biological basis to alcohol and drug addiction through like functional MRIs. So, the presumption that it's mental health, this is a mental health, not a physical diagnosis is, I would say it's, maybe I'm, really an advocate, but I would say it's all physical. And so calling it willful, I would say is there any way to surpass that? Because if there's a biological basis for it, then it's not really willful.
Congress. The only way to fix it is Congress. So it's all the federal programs, but you see the effects. I mean, you go outside, you look at the homeless. So we're treating all these diseases, physical and mental diseases, as diseases, and then we're treating drug and alcoholism as just something they're doing wrong. It's not really working for us out there.
And remember this, the reason it's willful misconduct is because in the armed forces, it's specifically prohibited.
Yeah.
Therefore, if you breach the regulations, it's going to be willful misconduct on its face. Now, but then again, Diane's already given you the way to deal with this, and that is that the drug and alcohol addiction, if the opinion of the doctor is such, then it's secondary, for example, to post-traumatic stress. We know, for example, that people who are suffering from PTSD, depression, anxiety, they tend to self-medicate. And there's another feature that really substantiates this, and that's the fact that it's also very much taboo to have mental health issues in active duty military service. So if you can't disclose that you're having a lot of stress related to the fact that your best friend was killed in action in a Humvee next to you, but you can't talk about that, and you've got to continue to go in the field, it might be when you get on leave that you start drinking a lot. That's self-medication. Now, if it's secondary to your PTSD, we can indeed have that. So that's the whole pathway. So your logic would be of value. It's just that it's got to really stem from a medical diagnosis in a secondary context. So your advocacy is sound, just always make sure that there's a medical practitioner who really understands what's going on. And the key is to have a release of information so you can have dialogue with that psychologist or psychiatrist. And then it'll work.
The other thing you want to watch out for, I've had a lot of case managers talk to me about this, and it's pretty logical. If they have a problem with drug addiction, that sort of thing, you may want to ask for a representative payee, because unfortunately we've had some overdoses and some deaths with people getting their back pay and blowing it on their drug of choice.
Right. So now we have to face the problem of paternalism in advocacy. How far do we go to get our client a protective payee, and when the client may evidently say, "Oh no, I don't
the
want
client
that.
doesn't want it.
I don't want that," but really they're not responsible for themselves. And there are other implications. If the client is found incompetent, they also lose certain civil rights. They lose their Second Amendment rights effectively. So there are a lot of issues here. And these are ethical issues. Maybe that's why we've got some ethics as part of the CLE. That's one of them right there. It is how far do you go in paternalism with your clients? What's appropriate? That's a question I'm not going to try to answer completely, but I think it's one for the discretion of the advocate and really how you work with the practitioner, especially if they're profoundly mentally ill.
So let's move on to the next slide. Okay, so these are common elements of getting people rated, and I know I talked about the analogous rating. Let's start with the benefit of the doubt doctrine. What this means, you go to VA, and VA has their C&P examiner medical opinion. Say it's my client, only one arm is busted and the other's fine. And then I have a second medical opinion and it says, both arms are busted, this guy is not fine. The benefit of the doubt says, if things are 50-50, the benefit of the doubt always goes to the veteran. So if you have one adverse medical opinion and one positive medical opinion, the guy gets benefits. The VA can find ways around this. We don't find that medical opinion very credible, that he didn't do X, Y, and Z. But yeah, that's a fight for another day.
That's why we go to the appeals court, because quite frankly, the VA will not find, but the appellate judge will. So we go to the BVA and Diane goes to CAVC as well. It's like that's where you argue benefit of the doubt, and it's one of the strongest laws on the planet. Next to the Constitution of the United States, benefit of the doubt and combat presumption, those are the strongest laws ever written. And they're always in favor of the war veteran. So it's beautiful.
There's also uncertainty is resolved in the veteran's favor, and what this means is if two ratings can apply, he gets the higher one. So that's something to check too. Sometimes VA will apply the wrong rating without really looking at it. There can be something higher that applies. No pyramiding means you can't take the same disability and rate it under different diagnoses. You can't take the knee and rate it 10 different ways when it's the same. Maybe not the same joint, but if it's the same disability in the knee. And 0% ratings, I want to encourage you guys to get 0% ratings. This isn't a loss. A 0% means it's affecting his economic livelihood 0% right now, but by getting the 0% rating, it means if it ever gets worse, and some of these things will, he's already got the rating. All he has to do is present to the VA medical records showing it's gotten worse, and they'll increase the rating to compensate for his economic loss. So the 0% is important because the hardest thing to do is the nexus. By getting the 0%, you've already done that. All the veteran has to do is go back and show it's gotten worse. Okay, we're almost done. There is math involved. Aggravation. So I know I talked about aggravation. This is the guy who played football in high school. He busted up his knee. He goes into the military and he blows it out completely. What they're going to do to rate him is they're going to look at how much they would have rated him when he goes in. And then they're going to look at how much worse it is now. And they're going to subtract. They're going to subtract the how bad it was from when he goes in. So my example is, this is a skin condition. The person goes in. He would meet the criteria for a 10% rating. He gets out. He would meet the criteria for a 60% rating. So they'll subtract that 10%. He'll end up with a 50% rating for aggravation. So that one's pretty easy. It gets worse. Okay, you'll have a lot of veterans come to you and complain about this, and this one is unfair. VA doesn't just add numbers. So if your vet is rated 50% for something and 40% for something else, he's not 90% disabled, he's 70% disabled. You can look up charts, you don't necessarily have to understand the math, but if you're trying to figure out what's going on here, here's how it works. So the VA, or the veteran gets the two ratings. You stack them from highest to lowest. So he's got a 50% and a 40%. You take 100% and you subtract 50%. He's 50% disabled. But he's still got this 40% disability. So you take 40% from 50%. And that's only 20%. All of a sudden, his 40% rating has become 20%. But you take the 40% from the 50%, you get 20%, you add that to the original 50%, you end up with 70%. I realize saying this, it probably makes no sense to anyone. It's a good way of giving them a lower overall rating. What they're basically saying is the more disabilities you have, the less disabled you are. It's just funny math. And you'll hear a lot of veterans complain. Some of them don't know right away, so they'll call you up and they'll say, hey, they added it wrong. If you can't understand the math, the best way to say is just VA uses funny math.
And we call it the handicapping table. When they come in angry, yeah, I'm 90%, and they give me 70. It's the handicapping table. Now we're going to show you the balance point, because there's generally something, just as in Taoism, there's going to be a balance point, and that, in this case, it's going to be the claim for individual unemployability. So there is a way to balance this out if your client cannot work and he or she is not 100% total and permanent, but they cannot work. If you've got certain ratings, and we'll teach you how to do that. So the handicapping table is one of the ugliest pieces of the Code of Federal Regulations. But that's what we call it with our clients, so maybe they can at least have something to name it, instead of where they're at.
Although if you talk to VA, they say they make it up with this. This is the last slide. Bilateral factors. This does not make it up, by the way. So you've got someone, two arms. Both arms are disabled. The left arm's 50%, the right arm's 40%. So with what I just taught you, you know that equals a total of 70. So since it's anything that you've got two sets of, since it's both of those, what they'll do is they'll take 10% of the total disability, so 10% of 70, which is 7%, and they'll add that to the 70%. And you get 77%, which rounds up to 80%. So they would find someone with a 50% arm and a 40% arm, 80% disabled with their bilateral factor. Granted, if you straight added, it would be 90%, but with their bilateral factor, they'll bring you up to 80%. You don't necessarily have to understand that either. Just have a general idea. If someone's got two sets of something, they're supposed to increase the total rating by 10%. Just have this general idea in your head. But that is it for, go for it.
Does that still apply if you have a disabled arm and disabled leg?
No. Got to be both arms.
Be the same.
Both arms, both legs. Yeah, so you don't really have a whole lot of twos.
And this math comes out of the benefits department or above?
It came out of VA. So the CFR, so Congress writes the acts, VA writes the Code of Federal Regulations. This is their rules. So this came out of VA. It came out of who wrote the Code of Federal Regulations.
It would be the Federal Register, you have to go look for this stuff and then.
Absolutely, it's under the APA. So you've got, I mean, we're not going to give a class on admin law, but basically, once you've got a statute that empowers the agency, then they're empowered then to make rules. That's the rulemaking side of the APA, the Administrative Procedure Act. And then once they implement those rules, notice in the Federal Register, notice and comment period, final regulations published, then they're codified into the CFR. At that point, then you go into adjudication under the APA. So, and that's a whole administrative law class. But that's the two pieces of the APA that the VA are actually utilizing under statute. Does that make sense?
Yeah, for a quickie, yeah, it makes sense, but it's just, you know, I'm sitting there going, oh, I got a project now, because there'll be people that I'll see, even in Veterans Treatment Court, they'll be talking about this kind of stuff.
Yeah.
So I would need to figure out, let's say, well, Mike, you know, this happens, that happens. I'll say, the VA has bad math.
Yes.
Yeah, and you can tell them, yeah, that's a bad part of the law. It's a handicapping table. There's nothing we can do about it at this point.
Yeah, so on the other side of that, then it'd be like, they might say, well, what can we do? And I'd say, well, we'd have to go to the Federal Register or wherever in order to get the politicians to do something to change it.
The real answer into what can I do is more practical. It's going to be continue to see your physician, make sure your doctor knows the extent of your problems, and we'll do our best to get you an increased rating when it's called for. That's the real answer.